Mduduzi Shembe's application for leave to appeal the Supreme Court of Appeal judgment has been dismissed with costs by the Constitutional Court. Mduduzi had approached the Constitutional Court to review the Supreme Court of Appeal, which had upheld the decision by the Durban and Pietermaritzburg High Court's ruling, which ruled in favour of the late Vela Shembe as a rightful heir to the Nazareth Baptist Church. This is how the judgment went earlier this morning.
This court refuses leave to appeal on the basis that the matter does not raise an arguable point of law of general public importance which ought to be considered by this court. It reaches this conclusion because the applicants have, in effect, sought to appeal against remarks by the Supreme Court of Appeal which are obiter dicta, that is, comments made in passing. In its judgment, the Supreme Court of Appeal accepted from the outset that the matter turned on a dispute of fact and that the factual findings of the trial court were unassailable. Having accepted that the matter turned on factual findings that could not be disturbed, the remark that the Constitution had been varied by the trust deed was simply by the way and not part of the judgment's ratio decidendi, that is the rationale or reason for the judgment. It follows that the applicant's appeal is an abstract and academic exercise at best, which this court ought not to entertain. In the result, the following order is made. Leave to appeal is refused. The applicants shall pay the respondent's costs, including the cost of two counsel. I hand down the judgment.